the City of Portland FAIR Ordinances in regards to the application process. There are some exemptions. Those landlords with exemptions to these ordinances are landlords with a unit that is affordable housing, where the rent is at 80% median household income or below, and the unit is subject to Multnomah County's Coordinated Access System. Landlords that have formal agreements with nonprofit service providers or government housing providers are exempt. If the unit is not advertised to the general public, if the tenant and landlord are living in the same dwelling unit or living next door to one another in a duplex situation, or if the tenant lives in an ADU on the landlord's primary residence. For all other landlords that have a unit within the City of Portland, FAIR ordinances would apply to them. If you are unsure if your unit is in the City of Portland, you can go to portlandmaps.com. The FAIR ordinance covers many different topics of the renting process. For this video specifically, we'll only be dealing with how to advertise rental units, collecting applications, processing applications, and screening fees. When a landlord wants to advertise a unit, under FAIR Ordinance guidance, they need to advertise the unit with a minimum of 72 hours notice before opening the application process. In their advertisements, they need to say how many units are available, the number of bedrooms and size of the units, the rent prices of the units, when applications will specifically be taken, whether or not the unit is accessible, and if there's a screening fee, how much it costs, and what their specific screening criteria is. If a landlord is choosing to advertise units that will have a wait list attached to them, they will still need to advertise those units with 72 hours notice. Unless this is a continuously open wait list, a landlord will need to create 2 wait lists, one for ADA units and the other for non-ADA units. The applications must include the following: the ability for an applicant to affirm a disability, the City of Portland's notice regarding tenant rights and reasonable accommodations or modifications, where to locate the City of Portland's statement of applicants' rights, that the landlord will review supplemental materials, and if they are charging a fee, then a description of the screening criteria and how the landlord will process the application. It is also highly recommended that they include their appeal process. When they're charging screening fees, there are 3 different ways for a landlord to charge the fee. If the entire screen is done through a third-party company, then they may only charge the exact cost of the screen through that third party. If the landlord is choosing to have some of the application but not all go through a third-party company, then they can charge the exact cost of the screen plus 25% of that cost. And lastly, if the landlord is choosing to complete the entire screen by themselves, they can choose to charge what a company in the area would charge plus 10%. When opening up the application process, there are key points along the way. Those being the announcement of any upcoming open applications. A landlord must wait that 72 hours at minimum before starting the application process and opening it up to the general public. Once the application process opens, there's an 8-hour window. That 8-hour marker serves as a buffer and has 2 purposes. The first, any applications that come in prior to the application period starting within that 72-hour window would receive a penalty of being shuffled to the 8-hour mark after the application period opens. This helps to incentivize people to only apply after the application period opens and not before. What that 8-hour window also does is if there is a unit that is ADA accessible, it allows for a buffer zone for those who state that they have a mobility disability to be able to apply and have preference to a unit that has an ADA designation that would fit their needs. And then the last step in this process is that the application period would close at some certain point. Other things to be mindful of during this application process is that there are a total of 4 types of applications that can come in. These application types are broken down to those that apply before the start of the application process, whether they have stated they have a mobility disability or not, and those that apply after the application process has started, whether they have indicated they have a mobility disability or not. Let's test drive this application process. We'll start by reviewing a unit that is ADA accessible. The same timeline applies to our unit that is ADA accessible. After an announcement has been made that within 3 days, the application process will begin, we already received 2 applications, one of them from an individual who stated they have a mobility disability and one that hasn't. After the application process has begun, these applications come in so they are within the first 8-hour window. And then perhaps we have one other person apply the following day. Even though this is the order of the applications that have been received, this is not the order that they will be screened in. Person number 4 is screened first before 1, 2, and 3 because they have applied after the start time of applications and within the first 8-hour window. This unit has an ADA designation, so they would be the first eligible person for this. The next person to possibly get screened for this would be person number 1. Even though they have the delay of an 8-hour window, they still are an individual who stated they have a mobility disability, that this unit may fit their needs. Because they have applied early, they do get pushed deeper back in that 8-hour window, but because it is still a unit with a mobility disability, they have their application set right before that 8-hour mark. The next to be reviewed for this is person number 3, and that is because they applied after the start time of the application process, and they did not state that they necessarily needed an ADA unit, so they would be screened before person number 2, who also didn't state that they have a need for an ADA unit, so person 2 gets pushed behind that 8-hour window mark. And then lastly, person 5 would be last in this because their application may be even a day after all 4 of these have already come in. In another example, for a unit that does not have an ADA designation to it, our application process is going to run slightly differently. Say the same 5 individuals applied for this unit. However, for the unit, in this situation, number 3 would be the first individual screened for this apartment. This is because their application came in after the start time of the application window opening, and they did not state that they had a need for an ADA unit, nor is this an ADA unit. So the 8-hour preference window for somebody who has a mobility disability would not necessarily be there. The 8-hour window would still apply for person 1 and 2, and it would kick them behind that 8-hour window because they applied early. If person number 3 didn't receive this, the next application to be reviewed would be person 4. 1, 2, and lastly, person number 5. Batch screening is different than first come, first serve. In the example that we looked at before, we have all 5 of these individuals apply. In most situations, a landlord will choose to do a first come, first serve application, meaning that the first individual with their application complete and their application fee in hand will be the first person screened. If they do not meet the screening criteria, the landlord will move on to the second person, so on, so forth, until they find somebody who fits the unit. In batch screening, the landlord may choose to wait until all 5 applications are in before they even move forward with putting the applications into the screening company. A landlord is allowed to do batch screening, though highly discouraged by fair housing laws. Regardless of whether they choose first come, first serve or batch screening, the way that they have to process the application will remain the same. They will still need to start with number 3 and then move all the way through until number 5. A landlord can refuse to process an application for 4 different reasons. If the tenant has had 3 or more lease violations to the same landlord in the last year, and the tenant also knew about those violations. If the application itself is incomplete, if the application fails to provide information on income or identification, and lastly, if an applicant lied on the application. For any of these 4 reasons, an application would be denied. If a landlord violates regulations, they are liable for up to $250 per violation, plus actual damages as well as reasonable attorney fees and costs. For more information on FAIR Ordinances, you can go to